Okay, a very good day to every one of you. Today we are going to look at the law of agency. Okay. So if we look at here, we are going to look at the definition first. Okay. So what is an agency? So an agency is a relationship between the two parties where we have the principal and the agent. So the principal is the person who gives the authority, whereas the agent is the person who receives authority. Okay, so the agent is authorized to act for the principal. So this means that the agent can make decision or do tasks on behalf of the principals. Third, the agent usually deals with the third party. Okay, so whatever the agent does within the authority given, it will bind the principal. So let's take an example. Ali owns a shop, but he is very busy. So Ali asked Abu to sell goods and collect payment from customers for him. So in this example, Ali is the principal, whereas Abu is the agent. So the customers coming in and out from the shop are the third party. So when Abu sells goods to the customers, it is as if Ali himself made the sales. Okay, so please remember that the agency is a relationship where an agent is authorized to act for the principal when dealing with a third party. Okay, so let's move on to the next slide. Here, we are going to look at the act, okay? We are going to look at section 135. Now, under section 135, first, who is an agent? Okay, an agent is a person employed by the principal. So the agent's role is to represent the principal when dealing with a third party. So in simple words, the agent acts for someone else, not for themselves. Second, who is a principal? So a principal is a person who authorizes the agent. The principal gives permission or authority to the agent to act on his or her behalf. So without the principal's authority, the agent cannot act. Okay, so let me give you an example. Lisa owns a car but wants to sell it. Lisa asks Amin to sell the car for her. So in this example, Lisa is the principal. So she gives the authority. Amin is the agent. So Amin represents Lisa. So the buyer is the third party. So when Amin sells the car to the buyer, the sales is legally Lisa's sales, not Amin. Okay. So next, we are going to move on to the creation of agency. So an agency relationship can be created in several ways. So there are 5 main ways as stated in the slides. So let's go through one by one and let me give you a short explanation for each. The first one is by express appointment. So this happened when the principal clearly and directly appoints an agent. It can be done orally or in writing. So the authority is clearly stated. Next, by implied appointment. So this happens through conduct or circumstances, not through clear words. Okay, the relationship is implied from behavior. So here is the action. Okay, the actions that shows an agent exists. C, by ratification. This happens when a person acts without authority, but later the principal approves the action. So once it's approved, the act becomes valid as if authority existed from the start. D, by necessity. This happens in an emergency situation. The agent acts to protect the principal's interests when communication is not possible. So the authority arises due to necessities. And the last one is by doctrine of estoppel or holding out. This happens when the principal allows others to believe that someone is an agent. So the principal is prevented or stopped from denying the agency later. All right? So let's go through one by one. So the first one is agency by express appointment. So agency by express appointment happens when the principal clearly appoints an agent. The appointment is made expressly, which means clearly stated. And according to section 140, okay, 140, this appointment can be made in two ways, okay, either orally or in writing. So as long as the principal clearly gives authority, an agency relationship is formed. There is no requirement that it must be written unless the law requires it for a specific transaction. Okay, let's move on to the next one. Agency by implied appointment. Okay, still under section 140. Now, agency by implied appointment means that the agent is not appointed clearly by words, but the appointment is implied from the situation. Now, according to the law, this type of agency may occur implicitly based on the circumstances of the case. This usually happens when the words or the regular conduct of the parties shows that a person has authority to act. Because of this behavior, it appears to the public that the person has authority to act on behalf of another person. So this is recognized under section 140. So let's look at the illustration to section 140, which is the implied authority. Okay, so when you look at the illustration, so this is the explanation. So A owns a shop in Kajang. However, A stays in KL, okay, in Kuala Lumpur. So the shop is managed by B. So B regularly will order goods from supplier C, and B places the orders in A's name and pay for the goods using A's money with A knowledge. Okay, so A knows about B's action and does not object. Because of this regular conduct, B is said to have implied authority from A, even though A never explicitly said B is my agent. A's behavior shows that B is allowed to act on A's behalf. Okay. So why implied authority exists? Okay, implied authority exists because B has been managing the shop for a long time, and B regularly deals with C, and A knows and allows it. To outsiders, it appears that B has authority. So the law recognizes B as A's agent by implication. Next, if we look at implied agency from the relationship of husband and wife, okay? So we are going to look at the second situations of implied appointment, which is implied agency from the relationships of husband and wife. So in certain situation, a wife is considered an implied agent of the husband. This implied agency exists only under specific condition. So when does this implied agency apply? So the wife is treated as an implied agent only when the contract made are for necessaries and the goods or services are suitable to their conditions and lifestyle. This usually includes daily household needs such as food, clothing, or basic living expenses. In this situation, the husband is treated as the implied principal, and the husband is liable for the wife's acts and contracts. Okay. Now, however, the law also allows the husband to rebuke or deny this implied authority. This means the husband can escape liability in 5 circumstances. So the 5 circumstances where implied authority can be rebutted. Okay, number 1, husband expressly forbids the wife from pledging his credit. So the husband clearly tells the wife not to buy goods on his account. Okay, number 2, husband expressly warned the tradesman. So the husband informs that the sellers not to give credit to the wife. Number 3, wife was sufficiently provided with goods. So the wife already has enough necessities at home. Number 4, wife was given sufficient allowance. The husband provides enough money for her daily needs. And the last one is the contract was unreasonable. The goods bought were excessive or not suitable for their lifestyle. Next, we are going to look at the third situations of implied appointment, which is implied agency under the Partnership Act 1961. So under Section 7 of the Partnership Act 1961, the law provides that each partner in the partnership is an implied agent to the other partners. So this means every partner can act on behalf of the partnership, and whatever a partner does within the scope of the business will bind the firm. So in this relationship, the partner who acts is the implied agent, and the firm or the other partners are the implied principal. So point for you to remember here is that in Section 7 Partnership Act 1961, each partner is an implied agent. The firm and other partners are implied principals. An act must be done in the course of partnership business. Next, we move on to agency by ratification. First, let us understand the word ratification. Ratification here means acceptance or approval. Okay? Agency by ratification means it happens when a person acts without authority or goes beyond the authority given, and later the principal accepts or approves the act. Once the principal approves, the law treats the act as if authority existed from the beginning. So how can a ratification happen? There are two main situations. First, when an agent exceeds his given authority. The agent does more than what he was allowed to do, but later the principal agrees to accept the act. Right? The next one, the second situation of ratification is when a person has no authority at all, but acts as if he has authority to act on behalf of the principal. So at the time the act is done, the person is not an agent and there is no authority given. However, after the act is done, the principal has a choice to accept the contract or to reject the contract. So if the principal accepts, the acceptance is called ratification. Once it is ratified, the contract becomes valid and binding on the principal as if authority existed from the beginning. Okay. So if the principal accepts the act that was done without authority, the agency by ratification exists. So once the principal accepts, means an agency relationship is created and the principal is legally bound by the contract. So the law treats the situation as if the agent had authority from the beginning. When ratification does not exist, if the principal does not accept the act, means there is no ratification and no agency relationship exists. In this case, the principal is not liable for the contract. So the effect of ratification. Once the principal ratifies an act done without authority, the principal is bound by the contract. So this means the principal must accept all legal consequences of the contract. Under section 149, the effect of ratification is retrospective. So this means the contract becomes effective from the date it was originally made, not from the date of approval. In law, it is treated as if the agent had authority from the very beginning. So now let's look at the condition for a valid ratification. So not every unauthorized act can be ratified. The law sets certain conditions that must be fulfilled. Okay. Condition number 1, contract done without or beyond authority. First, the contract must have been without authority or by exceeding the authority given. So if the person already had full authority, then ratification is not needed. Ratification only applies when authority was absent or exceeded. Condition number 2, contract must not be illegal. The contract must be legal. An illegal contract cannot be ratified even if the principal wants to approve it. Ratification cannot be used to make an illegal act lawful. Okay, so case reference here is Brook versus Hook. Now, in the case of Brook versus Hook, the court held that a principal cannot ratify a contract where the principal's signature was forged by an unauthorized person. So forgery is illegal, so the contract is void and ratification is not allowed. So let's continue with the conditions for valid ratification. Now, specifically for condition number 3 and condition number 4. So let's look at condition number 3. Agent must act in the name of the principal. For ratifications to be valid, the agent must act expressly in the name of the principal. So this means the agent must show that he is acting for someone else and not acting in his own personal capacity. Now, if the agent contracts in his own name, then the principal cannot ratify the contract later. So let's look at case Kingsley Maxted and Company versus Durand. Now, in this case, the agent was authorized to buy wheat at a certain price. So the agent exceeded authority by buying it at a higher price. And most importantly, the agent contracted in his own name, not in the principal's name. So the court held the principal was not liable to the third party and the contract could not be ratified because the contract was not made in the principal's name. Okay. So let's look at condition number 4. Principal must exist at the time of contract. Another important condition is that the principal must already exist at the time the contract is made. So if the principals did not exist, then ratification is not possible. Let's look at case Kellner versus Baxter. So in this case, an agent made a contract on behalf of the company, but the company was not yet registered and formed at the time. So the court held the company could not ratify the contract because the company did not exist when the contract was made. Let's continue. Condition number 5, principal must have contractual capacity. The principal must have the legal capacity to enter into a contract at the time of ratification. So this means the principal must be of legal age and of sound mind. If the principal has no capacity, then the ratification is invalid. Condition number 6, principal must have full knowledge of all material facts. Ratification is only valid if the principal knows all the important facts of the contract. If the principal ratifies without full knowledge, he is not bound. So let's look at case Marsh versus Joseph. So in this case, the principal ratified a contract but did not know how the material facts. So the court held says that the principal was not bound by the contract. Condition 7, Principal must ratify the whole contract. The principal cannot choose part of the contract and reject the rest. Ratification must be complete, not partial. Okay? And then condition number 8. Ratification must be met within a reasonable time. Ratification must be done within a reasonable time. If the principal waits too long, ratification is invalid. So let's look at the case, Metropolitan Asylum Board versus Kingham and Sons. So an agent bought eggs without authority. Principal tried to ratify 1 week later. So the court held says that ratification was too late and therefore invalid. Another case, Grover and Grover versus Matthews. So it is about insurance contract. Okay, so the insurance contract was ratified after the insured event had already happened. So the court held says that the ratification was not effective. So for condition number 9, ratification must not injure a third party. Ratification must not harm the rights or interests of a third party. This is provided under section 153. So if we look at the illustration B to section 153, so A holds a lease from B. The lease can be ended with 3 months notice. And then C, an authorized person, gives notice to A. So B cannot ratify C's notice because it would injure A's interest. So that no ratification is allowed. Okay, so a point for you to remember here is that principal must have capacity, must have full knowledge, must ratify the whole contract, must ratify within a reasonable time, and it must not harm the third party. Next, agency by necessities. Okay, or emergency under section 142. All right, so agency by necessity happens when a person has no authority, but due to urgent or emergency circumstances, the person acts to protect the principal from loss. So in such situation, the law allows the person to become an agent by necessities, even though no prior authority was given. The main purpose is to prevent loss or damage to the principal. So key for you to remember here is that no authority at the beginning, and there is a real emergency or necessity. So the action is taken in good faith, and the action is to protect the principal's interest. So now let's look at the situation. Just now, we learned that the agency by necessity happens when someone has no authority, but an emergency forces them to act in order to protect the principals from loss. Now, let's look at 2 common situations where agency by necessity may arise. Situation A, wife deserted without means of support. The first situation is when a wife is deserted by her husband and has no means of support. So in this situation, the wife may act as an agent by necessities, and she may pledge the husband's credit to buy necessities. This is only allowed when the husband has left her and she has no money or support, and the goods are necessaries only. Situation B, entrusted with another person's property. The second situation is when a person is entrusted with another person's property. If an emergency occurs and the owner cannot be contacted, and immediate action is needed to prevent loss, the person entrusted may act as an agent by necessities. So the key point for you to remember here is that no authority at first, emergency or necessity must exist, action must be reasonable, and the purpose is to protect the owner or principals from loss. Now let's look at illustration B to section 142, agency by necessities. Looking at the case of Great Northern Railway versus Swarfield. So in this case, the railway company, the plaintiff, was entrusted to deliver a horse belonging to the defendant to a certain destination. So when the horse arrived, no one came to collect it, and the railway company could not contact the owner. Leaving the horse unattended would cause harm and loss. So the railway company arranged for the horse to be kept in a stable and paid extra expenses to ensure the safety of the horse. Later, the railway company claimed the extra expenses from the horse owner. The owner refused to pay, arguing that the railway company had no authority to do so. So the court decision held that there was a real necessity, an immediate action was required, and the action was taken to protect owner's interest. Therefore, the railway company was an agent by necessities and was entitled to claim the expenses from the owner. Next, let's look at condition 1, real and actual emergency. The first condition is that there must be a real and actual emergency. This means there must be an urgent situation and immediate action is needed to prevent loss or damage. So mere inconvenience or personal difficulty is not enough. So let's look at a case, Sash versus Miklos in 1948. So in this case, M agreed to store furniture belonging to S. After some time, M needed the storage space for his own use. So M tried to contact S but failed. M then sold the furniture. S sued M for conversion, and M argued that he was an agent by necessity. So the court held says that there was no real emergency. M sold the furniture for his own convenience. Therefore, no agency by necessity existed. Okay, so the court said if there had been a real emergency, for example, fire destroying the house, then selling the furniture might have been justified. Condition number 2, agent must be entrusted with the principal's property. So the second condition is that the person must be lawfully entrusted with the principal's goods or property. A person cannot become an agent by necessities by simply taking charge of someone else's property without permission. There must be an existing relationship such as carrier, bailey, or custodian. So let's look at case Jebara versus Ottoman Bank. This case confirms that agency by necessity can arise only when the agent is already entrusted with the principal's property. In fact, when conditions are satisfied, when the conditions are fulfilled, an agency by necessity or necessity arises and the principal is bound by the agent's reasonable act done on his behalf. Okay, so point for you to remember here is that must be a real and actual emergency and no agency if act is for personal convenience. Agent must already be entrusted with the property and no one can become an agent by necessity uninvited. Next, condition 3, impossible to get the principal's instruction under section 167. For agency by necessity to arise, it must be impossible or impracticable for the agent to communicate with the principal. If the agent could have contacted the principals but failed to do so, then agency by necessities will not exist. Let's look at case Springer versus Great Western Railway Company. So in this case, the defendant agreed to carry the plaintiff's tomatoes from Jersey to Covent Garden Market. So due to bad weather, the ship arrived late. Workers were on strike and the tomatoes were deteriorating. The defendant decided to sell tomatoes at Weymouth, believing they would not arrive in good condition. So the plaintiff claimed damages. The court held The defendant was not an agent by necessities because the defendant failed to communicate with the plaintiff, even though communication was possible. Therefore, the plaintiff was entitled to damages. Okay, so simple explanation. If the agent can contact the principal but does not, the agent cannot rely on agency by necessities. Condition 4, agent must act in good faith. Another important condition is that the agent must act in good faith. This means the agent must act honestly and only for the purpose of protecting the principal's interest, not for personal profit or benefit. So if the agent acts dishonestly or selfishly, agency by necessities will not be recognized. Next, the effect of agency by necessities. So once an agency by necessities is properly established, the law produces three main effects. Effect number 1, agent cannot be sued by the principal. First, once the agent acts as an agent by necessities, the principals cannot sue the agent as long as the agent acted in a real emergency, in good faith, and to protect the principal's interest. The agent is legally justified in taking action. Effect number 2, agent is entitled to additional payment. The agent is entitled to be reimbursed or paid for extra expenses and effort incurred while protecting the principal's property. This includes costs that were necessary and reasonable. Effect 3, contract exists between principals and third party. Any contract made by the agent by necessity creates a direct contract between the principals and the third party. This means the principal is bound and the third party can sue the principal, not the agent. Next, agency by estoppel under section 190. So, agency by estoppel happens when the principal himself causes or allows a third party to believe that a person has authority to act for him, even though that the person is not actually an agent. Because of this belief, the third party acts on it, and the principal is prevented from denying the agency later. So the law protects the third party, not the principals. So key elements for you to remember here is that agency by estoppel exists when the principal represents or allows it to appear that a person is his agent. The third party believes that representation. The third party acts based on that beliefs. Okay, let's continue. So effects of agency by estoppel. Okay, so next is principal is estopped from denying the agent's authority. The principal is estopped, meaning legally prevented from denying that the agent has authority. This applies even if the person was never actually appointed or the principal never intended to create agency. Because the principal's words or conduct caused the third party to believe that authority existed, so the principal cannot later deny it. Next, principal is liable on the contract. The principal is liable for the contract made by the supposed agent. The contract is valid and binding on the principal. The third party can enforce the contract against the principal, not the agent. Next, the second situations of agency by estoppel. Agency by estoppel also arises when the principal fails to inform the third party that the agent has no authority or the agent's authority has been terminated. But the agent continues to act as if he still has authority on behalf of the principal. Because the third party is not informed, the third party honestly believes the agent still has authority and enters into a contract based on that belief. In this situation, the principal is stopped from denying the agent's authority, and the principal is liable for the contract. This rule exists to protect the third party. So now let's look at the important case that explain agency by estoppel in practice. Okay, so key effect of agency by estoppel. Under agency by estoppel, the principal is liable for the contract made by the so-called agent, and the principal is stopped or prevented from denying that the person has authority. This applies even if the agent acted without the principal's knowledge. So let's look at the case Freeman and Lockyer versus Buckhurst Park Properties. In this case, a company had 4 directors. One director, A, entered into a contract with a third party on behalf of the company. A had no actual authority to make the contract. However, the other directors knew about this contract and they did not inform the third party that A had no authority. Because of their silence, the third party was induced to believe that A had authority to act for the company. So the decision held, the court held says that the company was stopped from denying that A was its agent and the company was liable on the contract. This is clear case for agency of estoppel. Next, limitation. Limitation of agency by estoppel. Now, we learned that agency by estoppel arises when a principal induced a third party to believe that a person has authority to act on his behalf. Now, it is important to understand that agency by estoppel does not arise in every situation. Okay, an important rule is that agency by estoppel only happens when the third party is induced by the principal. If the belief is created only by the agent's own statement and the principal did nothing to create or support that belief, then agency by estoppel does not exist. Let's look at Armagas Limited versus Mundogas SA. So the fact of the case is that an agent falsely claimed that he had authority to grant a subcharter for a ship. The third party relied only on the agent's statement. The principal did nothing to represent or suggest that the agent had authority. So when the truth was discovered, the third party sued the principal. So the court held says that there was no agency by estoppel because the principal did not induce the third party beliefs. So estoppel requires a representations by the principal, not just lies or statements made by the agent. Next, let's look at the duties of an agent to the principal. So once an agency relationship exists, the agent owes several legal duties to the principals. So let's go through them one by one in simple terms. Number 1, duty to obey the principal's instruction. An agent must follow the principal's instruction as long as those instructions are lawful. If the instructions is illegal, the agent must not follow it. Number 2, duty to exercise care and diligence. The agent must carry out the work carefully and use the skills and knowledge that he has. The agent is expected to act like a reasonable person in that profession. Number 3, duty to render proper accounts. When required, the agent must keep proper records and give true and clear accounts of all transactions to the principal. Number 4, duty to pay all sums received. Any money received by the agent on behalf of the principal must be paid over to the principal. The agent cannot keep it unless allowed. Number 5, duty to communicate with reasonable diligence. The agent must keep the principals informed and communicate important matters as soon as reasonably possible. This is especially important in urgent situations. Number 6, duty to avoid conflict of interest. The agent must not place personal interest above the principal interest. The agent should not act for personal benefit in matters related to the agency. Number 7, duty not to make secret profit. The agent must not make any secret profit from the agency work. If secret profit is made, the principal may claim the profit or dismiss the agent. Now, let's look at the duties of principal to the agent. Number 1, duty to pay commissions or remuneration. First, the principal must pay commissions or remuneration agreed upon. This applies unless the agency relationship is gratuitous, which is free services. If the agent has done the work as agreed, the principal must pay. Number 2, duty not to prevent the agent from earning commission. The principal must not interfere or act in a way that prevents the agent from earning his commission. If the agent has already performed his part of the agreement, the principal cannot avoid paying by unfair action. Number 3, duty to indemnify and reimburse the agent. The principal must indemnify or protect the agent and reimburse the agent for anything done lawfully and in good faith while carrying out the agency. So these include reasonable expenses and losses suffered while performing duties. So that's all for today's lecture. I hope you understand, and I'll see you again in our next chapter. Thank you very much.